I'd like to call the Senate to order. Mr. Clerk, please call the roll.
Senator Barnett. Senator Barrett. Senator Blackman. Senator Blackwell. Senator Blunt. Senator Boyd. Senator Branning. Senator Bryan. Senator Butler to 36. Senator Butler to 38. Senator Carter. Senator Kaufman. Senator Chancellor. Senator Chisholm. Senator DeBar. Senator Delano. Senator England. Senator Fillingane. Senator Frazier. Senator Harkins. Senator Hickman. Senator Hill. Senator Hobson. Senator Horn. Senator Jackson. Senator Johnson. Senator Jordan. Senator Kirby. Senator McCon. Senator McDaniel. Senator McClendon. Senator McMahon. Senator Michelle. Senator Moran. Senator Norwood. Senator Parker. Senator Parks. Senator Polk. Senator Seymour. Senator Simmons of the 12th. Senator Simmons of the 13th. Senator Sojourner. Senator Sparks. Senator Suber. Senator Tate. Senator Thomas. Senator Thompson. Senator Turner Ford. Senator Whaley. Senator Wiggins. Senator Williams. Senator Younger. Mr. President, a quorum is present.
Thank you, Mr. Clerk. Will the senators and guests in the gallery please rise for the invocation to be given by the Reverend Reed McCaleb, who is the pastor of Mineral Wells Church in Olive Branch, Mississippi, and the invocation be followed by the Pledge of Allegiance of Senator Blackwell. Reverend.
Good afternoon. As I thought about this prayer this week, one of your former colleagues is a church member of mine, and he gave me a pep talk. And he said, speak from the heart and sometimes offer words of wisdom. I don't know how many words I can offer to the wise in a cathedral such as this, when sometimes I think the wisest thing I can do is listen. And maybe that is my prayer for all of us in a week like this. Listen to one another. May we pray. Eternal God, we thank you so much for these positions you have given us. We are not just stewards in our local communities, but we have been blessed with an honor to steward and guide and cast a vision here in our capital, here for this state. We pray that as we bring our passions, as we bring our cares, as we bring the concerns of our constituents to the table, that you would give us the wisdom that comes, not just from you, Lord, but the wisdom that comes in caring for one another, our neighbors, our people. Give us listening ears, guide our hearts and our minds, and give us words of encouragement, even in the difficult conversations that come. We believe that you, God, are for us. In the name of the Father, and the Son, and the Holy Spirit, we all pray. Amen.
Amen.
Join me in saluting the flag. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you for coming down today. Thank you, Reverend. Now the reading of the journal. Senator Polk, you're recognized.
Thank you, Mr. President. I move the Senate dispense with the reading of the journal.
Senator moves to dispense with the reading of the journal. All in favor signify by saying aye. Opposed, no. The ayes have it. Messages and petitions, Mr. Clerk.
Mr. President, there are none.
Committee reports. Senator Polk, you're recognized.
Thank you, Mr. President. I move the Senate dispense with the reading of the committee reports.
Senator moves to dispense with the reading of the committee reports. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Next to the reading of the titles of bills and resolutions. Senator Polk, you're recognized.
Thank you, Mr. President. I move the Senate dispense with the reading of the titles of the bills and resolutions.
Senator moves to dispense with the reading of the titles of the bills and resolutions. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Introduction of guest. Introduction of guest. Seeing none, we'll move to the calendar. Chairman Hobson, Senator Hobson. Item 1, 2, and 3, sir. Item 1, 2, and 3 pass and retain place on the calendar. Chairman Harkins. We're on item 4, Senate.
Thank you, Mr. President. I'd like to skip items 4 and 5 and have them retain their place on the calendar and go to item 6, House Bill 388, and have the title read.
Mr. Clerk, please read the title.
House Bill number 388, income tax, provides local governmental entities that may collect debt by set off against the debtor's free fund.
I'll make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Move we adopt the strike all and recognize Senator Johnson to explain the strike all.
Senator Johnson, you're recognized.
Thank you, Mr. President. This strike all would add to the definition of local government, community hospitals for purposes of debt collection through income tax refunds from the state, and that's an explanation of the strike all.
Questions? Senator Butler, for what purpose, sir?
Question, Mr. President.
You have Senator Johnson.
Yes, sir.
Senator Butler is recognized for a question.
Thank you, Mr. President. Hey, Senator, last week we passed a bill where we talked about cutting down on the amount of money that they can garner.
Garnish, yes, sir.
All right, now what is the difference in that and this?
So that had to do with when you owe back income taxes, and this is a debt to the hospital, and the other garnishment was against wages, so your actual paycheck wages. This would be against your income tax refund. So it would not be a garnishment on your wages, it would be against your income tax refund.
Okay, so they would get what, 100% of your income?
Up to that, just your income tax refund. So if you are due a refund from the state of $1,500 and you owe $5,000, it would take a refund from the state, but this has nothing to do with their paycheck as a garnishment.
How is it now?
I think currently there are local governments can take your income tax refund from the state if there's a debt. However, we're adding to the definition of local governments community hospitals. So community hospitals are currently not part of that definition. And so if you have a hospital debt, that would be new to a community hospital.
Thank you, Senator. Thank you, Mr. President.
Senator Hill, for what purpose, ma'am?
Question.
Are you here for a question, Senator Johnson?
Yes, sir.
Senator Hill is recognized.
Thank you. I'm looking on lines 12 and 13, 14. We passed a very similar bill through County Affairs last week or so, and it actually had language in there that was very similar, but after it had through their nonprofit member organizations, we had language that said whose members are or whose majority of members are appointed by that local government entity, but this doesn't say anything about appointed members. So I'm wondering as to why the original bill that we had that provision in there that it would have to be a majority of appointed members, but this version does not.
You have me at a disadvantage. I'm not familiar with that bill or the reason that language was in your bill and not this bill.
Does this bill have a reverse repealer in it?
It does not.
Okay, that would be a concern that I would have because the language that was given to me by the boards of supervisors originally said that the members would be the majority members of whatever entity, and it's not necessarily a nonprofit. Some of these like utility authorities, sewer, water and sewer associations, would that be what you're considering as a nonprofit? Because they're basically a political subdivision. So I'm wondering who the nonprofits are. I don't want to vote against the bill, but I'm just trying to get some clarity.
Yes, if you'll give me just a second, let me
Sure.
see if I can.
Sure.
So I think if you look at F, maybe line 29, where it has member organization, I think that would be more clear on what they define for that.
Okay, I thought several years ago we passed a similar bill through 4 community hospitals, that we already had language on the books that allowed the debt set off for community hospitals. Maybe I'm wrong, maybe it didn't pass the House, but I know we passed it through this body. So I understand that we've got community hospitals in here, but would this also include like utility authorities or some type of other political subdivision, fire department, or anybody else who might be owed a debt that's a political subdivision of a city or county?
So the new language.
Because nonprofit, I don't know if that cuts it.
Yes, so the new language is specific to hospitals, but I'm happy to work to get you an answer on the
So
other.
I don't think passing this bill, would this bill negate the other bill that we've already passed that would include that language?
Well, I assume that's in a different code section. I'm not sure how that would affect it. I'm happy to ask counsel.
Yeah,
I'm just not
I
familiar
think
with your bill.
Caleb probably had that bill. Pardon? Okay, so that bill died. It was not taken up.
So no,
Okay.
it would not affect it at all.
Okay, well, I still don't know about nonprofit other than community hospitals. Are there other nonprofits that would be other than a community hospital?
Yeah, again, the language in this bill is specific for community hospitals in the new language. So I'm not aware of any other nonprofit that a county or city would have. And again, the new language in this is specific to hospitals.
Thank you.
Other questions? Seeing none, we're ready for your motion, Senator.
Move adoption of the strike all.
All in favor signify by saying aye. Opposed, no. The ayes have it. We're ready on the bill.
If there's no questions, move passage using the afternoon roll call.
Afternoon roll call has been requested. Anyone object to procedure? Board is voting no. Present. Present. Hill. Anyone else? Seymour. Present. Anyone else? Turner Ford. Present. Anyone else? Anyone else? Seeing none, the bill passes. Item 7, Senator Harkins.
Thank you, Mr. President. I'd like to skip item 7, have it retain its place on the calendar, and go to item 8, House Bill 968, and have the title read.
Mr. Clerk, please read the title.
House Bill number 968, sales tax and use tax, provides provisions regarding computer software service, computer service.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed.
I move we adopt the strike all and be recognized to explain
You're
it.
recognized to explain your strike off, Senator.
Thank you, Mr. President. Ladies and gentlemen, this is just the Senate language we put in this bill to bring the code sections forward. We've been having several meetings with the Department of Revenue, working on a version of the bill to deal with the use tax on software as a service. That's the issue we've talked about a couple times. We're pretty close on getting a final version that we'll have ready for conference for us to look at, and it's a pretty technical issue that we've lots of definitions, and there's a lot of meanings that we were having to kind of go through for different sections and make sure they don't cross up. This version does have a reverse repealer in it, so it will be going to conference. So that is an explanation of what this bill does. It just brings code sections forward like we did in the Senate language. If there are no questions on the strike all, I move adoption of the strike all.
Questions on the strike all? Seeing none, all in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Now we're on the bill.
If there are no further questions, I move passage by the afternoon roll call.
Anyone object to procedure? This court is voting no. Present. Seeing none, bill passes. Thank you, Senator. On 9.
I'd like to skip item 9, have it retain its place on the calendar.
Item 9 retains place on the calendar. Motions to reconsider. Pass and retain. Senator Horn, for what purpose?
Thank you, Mr. President. I'd like to enter a motion to reconsider on House Bill 772. I believe it was on last Wednesday's calendar.
I don't know which day. Senator Clark.
Okay, I think it was Thursday, sir. So, Mr. Clerk, please read the title.
Bill 772, Mississippi Opal, designate as official state gemstone.
Thank you, Senator. Yes, sir?
I understand that a Senate bill that does the same thing has already been signed by the governor, so we need to kill this bill and let it down the calendar.
Thank you, Senator. Anyone else? Concurrence or non-concurrence? Concurrence or non-concurrence? Senator Michelle. Are you on 17, sir? 13 through 16 retain their place on the calendar.
Go to item 17 and ask the title be read, please.
Mr. Clerk, please read the title.
Senate Bill number 2622, Mississippi Prior Authorization Reform Act, enact.
My motion is that we do concur, and I would like to be recognized to explain the changes made by the House.
You're recognized, Senator.
Thank you, Mr. President. This is our prior authorization bill. It passed 49 in favor, and no one voted against it. Now, the House actually made it a couple of changes to the bill, I think, that have made it a better bill. The insurers, you might recall, were to set up a web page portal by January 1st of 2024, and the House change is such that not later than January 1st of 2026, healthcare providers shall be required to use the portal. Also, they changed in the appeal process that physicians who are licensed outside of Mississippi would be available to review appeals instead of just those located in Mississippi. There were peer-to-peer reviews, and it was a concern that in some specialties there may not be enough people licensed in Mississippi to be able to respond to that need. Also, all the fines that were to be collected by the department shall be deposited into the state general fund. And Section 20 was changed and states that a health insurance issuer has, if they have a reason to believe that a healthcare professional or provider has knowingly and willingly submitted a false or fraudulent request for a prior authorization to the issuer, then the issuer shall notify the Commissioner of Insurance. We think this is good language. We surely don't want false or fraudulent reports being filed, and this is in line with our getting accurate reporting. Our motion is that we do concur by use of the afternoon roll call.
Questions? Questions? Seeing none, all in favor signify by, I'm sorry, you're right, because this is a motion on acceptance. Does anyone object to the procedure? Mr. Recorder is voting no. Present? Seeing none, concurrence. 18, Chairman Turnford.
Thank you, Mr. President. I request that item 18 on today's calendar be called up in title read.
Mr. Clerk, please read the title.
Senate Bill number 2723, certain real property located in the Capitol Complex area, authorize DFA to purchase.
And I request permission to explain the basis for requesting that the body concur in the changes from the House.
Please proceed, Senator.
The House submitted a strike all, but they basically corrected the legal description for the property, and after conferring with Glenn Cornbreck, who works in the Bureau of Buildings, he stated that the House language is correct, so I move that we concur.
Questions on the concurrence? Seeing none, Senator, we're ready for your motion.
I move that we concur based on the use of the afternoon roll call.
Afternoon roll call has been requested. Anyone object to procedure? Court is voting no. Present. Seeing none.
There's no.
Whoa, here we go. No Horn. No Blunt, sorry, didn't see you. Norwood, no. Frazier, no. Present. Simmons, D. Senator Butler, how did your vote cast, sir? Present. Senator Albert Butler, present. Anyone else? Anyone else? Okay, concurrence?
Thank you.
Thank you. Chairman Pope? Brian? Michelle? 20 and 21 retain place on the calendar. Item 22, Senate.
I'd like to go to item 22, Senate Bill 2615, and ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2615, contract personnel, authorize the purchase base plan of the state and school employees' health insurance plan.
My motion is that we do concur, and I'd like to be recognized to explain the changes.
You're recognized, Senator. Explain the change.
Thank you. This bill dealt with an unintended consequence from the Affordable Care Act. Some of the contract workers for the state, we were being penalized because we were not offering them health insurance on our state health plan. So the good news is that we must be able to afford to offer this to the employees, but 100% of the cost is to be burdened by the employee, at no expense to the state. The House changed the language which we had in the bill from employees who worked at least 30 hours in a week to 130 hours per month, which is just about the same math, but that's what they chose to do. And also put language in it that the state employees' health insurance management board shall establish the premiums. I didn't think that was necessary as well because our management board does do that, but rather than go to conference with the bill, I think that we should concur and send it on to the governor. So that's my motion, that we do concur by use of the morning roll call.
Senator Michelle?
President, I'd like to amend my motion, please.
Yes, sir.
Senate Bill 2615 retain its place on the calendar for further study.
Thank you, Senator. Thank you, Senator Michelle.
Thank you.
23, Chairman Bryan. 24, Polk. Wiggins. Polk. Carter. Delano. Kaufman. Pass. We'll pass on all of those through item 30. Chairman Michelle. 31. Jordan. Senator Jordan. Pass. Bryan. Pass. Polk. Pass. Moran. Pass. We're down to 38. Senator Wiggins. Okay, Senator Wiggins, we're on 38, Senate. Senator Jordan, for what purpose, sir, do you seek recognition? There we go. Thank you very much. Okay, we're on 38, Senate. Senator Wiggins.
Thank you, Mr. President. Go to item 38. Call that up. Ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2652, Mississippi Vulnerable Person Abuse Registry create.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it. You don't need to do that, but it's fine. Let's go.
Sorry, Mr. President, my motion would be that we do concur and I be allowed to explain the bill,
You're
the
recognized.
changes. The House took out the reverse repealer, and then there was one technical amendment that we actually had asked them to do from what we sent over to them, and they did that. And so with the exception of those two minor things, the bill's the same as it passed the Senate. And again, this is the bill to create the Vulnerable Person Abuse Registry. Be happy to answer any questions.
Senator Barrett, for what purpose, sir?
Question.
Are you here for a question, Senator Wiggins?
Yes.
Senator Barrett's recognized for a question.
Thank you, Mr. President. Thank you, Mr. Chairman. This only applies to persons or people that were convicted of the crime, correct?
Correct. And there was some language that mentioned about, put it this way, that was the change that was made by the House to only limit it to conviction.
Thank you.
Okay, other questions? Other questions? Senator Hill, for what purpose, ma'am?
Question.
Were you here for a question?
I do.
Senator Hill is recognized.
I know it's a little late to be thinking about this, but it just came to my mind. What about access to this list for someone who might be wanting to hire a caretaker for a vulnerable person?
That's what this does is it allows that to be determined, to be accessed. The Attorney General's office is to make out rules and regulations about how that can be accessed. And the goal of this is so that somebody who's been convicted of that cannot be hired again.
Okay, I just don't see how if someone, looking at the language here, the underline, I don't see how someone who is just a caretaker would be able to access the list to see if somebody was on it.
I'm sorry, are you looking at what the House sent us?
I thought I was. I was looking at lines 243 through 251. Is that the
Okay.
underline?
Yeah, so that goes back up. That was in the original bill that we sent the House.
Okay.
And that details about the reports. If you look over in section 1 and 2, it talks about those folks having access to it. Line 64, a member of the public may request permission.
Okay.
59, line 59, a care facility shall query the registry who's applying to be there.
Okay.
And then the Attorney General's office is to, if you look at line 52, shall adopt rules requiring due process and so forth and so on.
Okay, I just want to make sure that a person of the general public would be able to look at that before they hired a caretaker.
That's line 64.
Okay, thank you.
Thank you, Senator Hill. Anyone else? Anyone else? Okay, Senator. You ready for your
My motion is that we do concur and send it on to the governor
By use of the afternoon roll call.
by use of the afternoon roll call.
Anyone object to that procedure? Court is voting no. Present? Seeing none? Concurrence. Chairman Delano. Chairman Delano? Pass. Polk? Pass. Chasnaw? Chairman Chasnaw, pass. Parker? Pass. Hobson? Pass. We're Hill? Pass. Hobson? Harkins? We're on 50, Senator? On the concurrence, non-concurrence calendar, item 50. All of the above retain their place upon the calendar.
Thank you, Mr. President. I'd like to skip item 50, have it retain its place on the calendar, and go to item 51, Senate Bill 2695, and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2695, Tourism Project Incentive Program, extend deadline for MDA issuance of certificates approving participants.
My motion is we invite conference.
Questions on the motion? All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. 52, Senator.
I'd like to skip item 52 and have it retain its place on the calendar and go to item 53, Senate Bill 2703, and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2703, driver's license fees waived for applicants in MDCPS custody.
My motion is that we do concur and be recognized to explain.
You're recognized to explain concurrence.
The only change that the House made in this bill was basically conforming the part about they deleted the intermediate license language in here. We got rid of intermediate license a while back, and so this bill just the House, all they did was remove the language about intermediate license on the bill. That is an explanation of the changes. And this bill basically removes the fee for a license to any applicant that is in the custody of the Department of Child Protective Services.
Questions? Seeing none, ready for your motion.
Motion is we concur.
By
By the afternoon roll call. Excuse me.
our group is getting a little slower today, so afternoon roll call. Anyone object to the procedure? Wish to be recorded as voting no. Present? Pass. Thank you, Senator. 54, sir.
54, I'd like to call that item up, have Senate Bill 2842 read, title
Mr.
read.
Clerk, please read the title.
Okay. 52.
It's item 54, sir.
54.
2842.
Senate Bill number 2842, use tax, revised standards for municipalities, eligibility to receive monies from Special Infrastructure Assistance Fund.
My motion is we invite conference.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Conference invited. 55, sir. Senator on 55, Senator Hawkins. I'm sorry, it's local and private. That's right, Chairman McMahon, I'm sorry. All right. 56, pass and retain. Now, in conference, those are 57. Through how much? What is it? Yeah, I missed that. Just 1 second. Through item 61, pass and retain. We'll go to Chairman Seymour. Pass and retain 62, 63. Chairman Fillingane. Pass 64. Chairman Branning. Pass 65 to 67. Chairman Parker. Pass. Parks. Pass. Wiggins. Chairman Wiggins. We're on item 70. Senate.
Thank you, Mr. President. Go to item number 70. Call that up. Ask the title be read.
Mr. Clerk, please read the title.
House Bill number 246, real property right of first refusal expires on grantee's death unless specifically stated otherwise.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Mr. President, my motion will be that we adopt the strike call and ask that you let Senator McConnell explain the bill.
Senator McConnell, recognized to explain the strike call.
Thank you, Mr. President. Thank you, Mr. Chairman. This bill is a lawyer bill, and I'm sorry for that one. On a Monday of all things. But it really is aiming at a concern that there are out there in some of the real property world. If someone were to reserve a right of first refusal, this bill specifically states that if the right of first refusal was reserved by Tyler McConn, and then at that point I were to die, it would specifically expire, unless there was additional language in there to say that it went further. So if it were reserved by myself and my spouse, then my spouse would still have the right of first refusal out there because it was specifically notated on the face of that deed or that instrument. But if it were just reserved by me, then it would specifically expire upon my death, which in general should be remembered by most in real property of all the things that we go through in Blackacre and Whiteacre and all the things they teach you in Greenacre in the practice. But at this point, that's all it really says. But now you can specifically state I reserve the right of first refusal for myself and my children, or for one additional generation. You can still do that. But for some reason, in some parts of the state, this has been a concern. It does extinguish at the death of that grantee, being that right of holder. And I would entertain questions at this time, Mr. President.
Senator Parks. I'm sorry. Senator Hobson.
Thank you, Mr. President. Question.
You have a question, Senator? Senator
Yes.
Hobson, you're recognized.
Thank you, Senator McConn. What about rights of first refusal that are already filed in the courthouse? Are those, and it's for the person that may be living, filed it 10 years ago, would this be applicable to them, or is this going to take effect just upon passage or July 1, 2023?
I would entertain your guidance on that, but the way that I would read this is that if you actually have a right of first refusal, if you were reserved one yourself, this just clears up that upon your death it would expire. But if you were to reserve it for yourself an additional, which generally an attorney who's drafting a deed would do that, or if the will itself and that was probated were to reserve that, it would reserve for additional people or additional generations as specifically stated in that instrument.
All right, but if I did this 10 years ago, would the right of first refusal be able to be utilized by my children or my spouse or some other person in succession?
Well, as such, and I want to be sure that I understand your question, and I'm afraid, unfortunately, we probably will need an instrument to look at to really get this right between the two of us. But if that instrument were reserved by you 10 years ago, you filed a deed 10 years ago, reserved the right of first refusal to purchase this property from whomever, and we are now 10 years down the line and you're still alive, it's still effective for you. But if you just did it for yourself specifically, I would entertain that it would expire anyway, even without this language, if it was personally reserved to you.
If it was vague in a document or unclear in a document from 10 years ago, do you think that you would lose out on the right? In fact, if you negotiated it in a contract with another party as part of some compensation that, the price was increased because you wanted that right of first refusal, would it still just apply to the person that entered into it, or could the heirs at law, if it wasn't clear 10 years ago because they didn't know that was the change in the law at that time?
So, my understanding is you brought up the vagueness of the right as reserved in that instrument, and this bill does specifically state that if it was unambiguously stated, if there's an ambiguity in the instrument itself, of course that will go to a different set of standards if it were litigated. But if it were no ambiguity in there and it was just a straight instrument, it would provide for it to continue to your heirs and assigns. But if there is an ambiguity in there, I'm afraid that this instrument would go into effect at this point, and thereby it would be ruled by this instrument. Are these rules on this right of first refusal as is being passed in this bill.
So let me make sure, I'm sorry to keep asking this separate ways, but if it's ambiguous in the document that you entered into 10 years ago, and I die, and it's not clear, then my children or my spouse wouldn't get the benefit of the ROFR.
If it's ambiguous, this instrument would, this bill would actually go into effect in July, and it would reflect back upon that instrument itself.
Thank you, Mr. Chairman. Thank you, Mr. President.
Senator Thompson, for what purpose? You here for a question, Senator? Senator Thompson, recognized for a question.
Thank you, Mr. President. Senator McCollum, does this proposed legislation, is it to address any specific decision or case? Is this something that's going on in the property realm right now?
I believe you state this rather interestingly, that it's not my baby, but I'm rocking it. And at the end of the day, I don't know of any current opinion of the Supreme Court or current litigation that's going on that this is aimed at. We do have two House members that have provided this bill, Representative Sanford and Burnett, and I would entertain if there are questions about a specific instance, they may have some additional insight.
Thank you, sir.
Senator Johnson, for what purpose, sir?
Question?
You here for a question, Senator?
I do.
Senator Johnson, please proceed.
I just want to make sure that I'm following along. What I understood from Senator Hobson's question, the answer is that if I have a first right of refusal from several years back, and I did not specifically state that it would go to my heirs or assigns in the future, and I pass away, then that first right of refusal is wiped out. Is that what I understood you to say?
So actually, if I were running your title and you reserved it yourself personally, it would wipe out upon yourself. You reserved it personally, not until your heirs and assigns.
Okay. And that's how it works now?
That's how I review the statutes, and that's all the real property law that I've been through.
And so what does this do exactly?
It just clears that up in the statute, is my understanding of the bill.
Okay. And unlike an option where, if I have an option and I pass away, that would go to my heirs or assigns.
Correct.
And I would view an option like an asset in my portfolio.
That's right.
But would you not look at a first right of refusal as a potential asset in your portfolio as well?
Well, if it's an asset in your portfolio and you're actually working properly to get it through, as an attorney, I would not leave anything to chance, in which case I would expect your attorney that provided you with that right of first refusal in the drafting process would have very likely put in place the contingencies where you, or it may have been your business that owned it at that time, that owns that right of first refusal, would continue to retain it.
Okay, but this would be clearing it up retroactively.
Okay. Sir?
This would be clearing it up retroactively?
It would specifically state it. Now, I have no objection if there wants to be some additional language put in, but at this point, if you were to reserve one and you passed away, your right of first refusal is gone because you've expired this life.
Okay. All right. Thank you.
Further questions on the bill?
Okay. I believe you've already got a motion to adopt the committee sub, Mr. President. Strike all.
The strike all, that's correct, sir. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator.
And Mr. President, I would ask for final passage based upon the morning roll call.
Anyone object to procedure? Court is voting no. McDaniel, no. Thompson, no. Sojourner, no. Williams, no. Hill, no. Seymour, no. Barrett, no. Johnson, no. Blackwell, no. England, no. McClendon, no. Turner Ford, no. Parker, no. Chisholm, no. McMahon, no. Butler, no. Norwood, no. Simmons, no. Jackson, no. Frazier, no. Jordan, no. Blackman, I believe we got you already, Senator. No, yes. Blackman, no. DeBar, no. Harkins, no. Horn, Horn, no. Thomas, no. Whaley, no. Blunt, no. Hickman, no. Barnett, no. Sparks, no. Butler, A, no. Younger, no. Kirby, no. Sorry, Senator, I didn't see your hand. Kirby, no. One moment, please. I believe the bill failed. I was accurate. The bill fails. Senator Wiggins.
Mr. President, I'd hold that on a motion to reconsider.
Motion to reconsider. Okay, 71, Senator.
Okay, we're going to try this again. We're going to go to item number 71. Call that up, ask the title be read.
Mr. Clerk, please read the title.
House Bill number 685, deeds to married couples, create a rebuttal presumption of joint tenancy with rights of survivorship.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Thank you. Now, this too is a lawyer bill. And I'm going to explain three things. There's a thing in property law called tenants in common. It's also called tenants with rights of survivorship, and there's a thing called rebuttable presumption. If you are not married and you deed property, that's generally going to be tenants in common. And the current law in the state of Mississippi is tenants in common. That's what the code section 8917 is. When you're married, 90% of all those deeds are rights of survivorship, because when you die, it automatically, without doing anything, goes to your spouse. That's what generally people want. And so what this bill is doing is to simply, and there's been errors found in deeds that leads to the question of, did it mean tenant in common or was it rights or survivorship when the parties were married? And so what this does is simply says the presumption is that it's rights or survivorship. And a rebuttable presumption is, if that's not the case, then a party can challenge it, but the presumption and show otherwise why it wouldn't be that. And so the optimum language is there in lines 30 through 38, where if you're married, then the deed conveying the interest shall create a rebuttable presumption that it's the primary residence of the individuals. That's, by the way, is generally how you get your homestead and when you married with your spouse. So with that, Mr. President, I'd be happy to answer any question.
Questions on the bill. Senator Norwood, for what purpose, sir?
Question, Mr. President.
Will you for questions, Senator? Senator Norwood is recognized.
Yes.
So, Senator Wiggins, friendly question. If I'm married, and just that the property is in my wife's name.
I'm having a hard time hearing you say that.
So if I'm married, the property is in my wife's name, not my name, but we're now married. Would the same thing apply?
So this only applies, well, let me put it this way. Property, if you're married and the property's only in your wife's name, it wouldn't apply.
It wouldn't apply.
Right.
So So in that case, what's hers?
And also, it's not retroactive either.
Okay, thank you, Mr. Thank you.
Thank you. The purpose is to simply clear up, because what happens, I'll do it, is two members, they're married, they do the deed, and for whatever reason, it doesn't say rights or survivorship, it's automatically tenants in common. But when they were married, that was the whole purpose of it. And so that's just simply clearing that up.
Senator Fillingham, for what purpose?
Question.
You for a question?
Yes.
Yes. You're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. I'm just curious, so currently, just to keep me straight here, if you have, husband and wife on a deed, if it doesn't say the magic words as joint tenants with full rights of survivorship, then the default right now is that it's a tenants in common holding.
Correct, which is current law 89-1-7, which is what the current law is. That's correct.
So are we trying to change that so that if you are married and you were married when the deed was created, that there is an automatic?
It creates a rebuttable presumption.
And how would you rebut that, I guess, would be the question?
Through proof of, like, for example, you talk to the lawyer. I've had cases where somebody comes in and says, oh, that was supposed to be rights of survivorship. And I said, well, no, it's tenants in common because they're, and then you ask either via an affidavit or something like that. And in practice, you file what's called an affidavit in the land records and say, oh, this was supposed to be either a Scrivener's error or technical error, and you do that. This way, this is simply creating that. In the marriage, the idea behind that is generally you want your property to go to your spouse, although that's not always the case, but when you die, it goes to your spouse.
Okay.
Without having to open an estate and probate. I think, as you know, if you do it through deed, then you don't, and it automatically works that way, you don't have to open an estate, it's done, or probate.
So when it says, and such property is the primary residence of that married couple, do you look to the homestead records for that? Or how are you determining that it's the primary residence?
Yes, you can look at the homestead records, because that's where that would naturally be. Or you look at, you talk to the drafting attorney who did that originally.
Mm-hmm. Okay. But in every other instance, if you leave the JTROS language off, it's still to be considered a tenancy.
That's the effect of the current law. That's correct.
But even after this passes, so this only applies to married couples who are primarily residing in that house.
That's right.
So the language on the deeds.
But as you know, you don't have to be married. You can say rights of survivorship in the deed if you want to do it.
Right. Okay. All right.
But most people who are not married, it tends to be tenants in common. Now that everybody's asleep.
Senator Branning, for what purpose?
Question, please.
You have for a question, Senator?
Yes.
Please proceed, Senator Branning.
Thank you, Mr. President. Mr. Chairman, let's talk about sort of the problem that we are trying to cure. Right now, under current law, and I apologize to you if this question has already been asked, but under current law, if there is no specific designation in a deed and a married couple owns, let's say, a homestead, and perhaps a husband dies and they've got minor children, and you have a wife that can no longer continue to afford that residence and it's time to sell, what happens in that instance?
Well, if it's rights or survivorship in the deed, then it goes to the wife automatically, and then she can sell that house, and then if that's what they want, and then distribute the property, or that house can be deeded to the children.
If there is no designation in the deed that says joint tenancy in that situation, what would happen?
Then it's split between the two. It would be each would own 50% of one, and so she would only then have 50% to pass down or to sell. So if you sell it and the house is worth $100,000, she and the kids only get $50,000 rather than getting $100,000.
How difficult is it to go through Chancery Court to establish a conservatorship, to get authority to sell the real property? That's more time and money for potentially a lady who's just lost her husband. Would you agree with that?
I would, and you're looking at least, depending on type of it, you're looking at least $3,000 to $5,000, depending on where you are. Time, effort, and money. If you just do it through the deed, and there's a lot of cases where all somebody has in their, when they die in their estate, is just a house, and under the scenario you're talking about, you would have to go to court and do all that. Whereas if this prevails, then you don't have to do all that. It's by what we call operation of law via the deed.
Thank you.
Thank
Thank
you.
you for your work on this.
Senator England, for what purpose?
Question, Mr. President.
For a question, Senator. Senator England,
Yes.
recognized.
Senator Wiggins, this is probably just a basic question, but you've used a phrase a couple times that I just wanted to get some clarification on. You mentioned when married people do the deed. What is that all about?
When they look at each other staringly in each other's eyes and they do the deed in the lawyer's office.
Okay, I need to look into that law practice. Thank you, Senator Wiggins.
You're welcome.
Senator Turner, for what purpose, ma'am?
Question.
You for
Yes, I do.
Please proceed.
Thank you, Mr. President. Thank you, Mr. Chairman. My question is, if this bill passes and a married couple intends, they don't want to include survivorship language, then how should the deed read?
If they're married or not married.
If they are married, but they do not want to
Right, which that can happen, and then they would make sure and tell their attorney to put tenants in common in there. Okay, the law says right now, if you read the current law, shall be construed to create estates in common and not in joint tenancy, all conveyance or devise of land made to two or more persons. So if you and I were conveyed property, because we're not married, it would automatically be tenants in common. And then to married couples, they can certainly do it, and they just have to say, hey, tenants in common. Because most married couples, when they have a deed conveyed to them, want it to go to their spouse upon their death.
And so the requirement would be that the deed must expressly state that it's tenants in common.
I think that would be the safe way, yes.
Thank you.
Senator
I think it would be the safe way, yes.
Senator Sparks, for what purpose, sir? I'm sorry, Senator Hobson's light, but he's standing over there.
For a question, Mr. President.
You yield, Senator.
Yes.
Please proceed.
Thank you, Mr. President. Thank you, Mr. Chairman. What does this do to a child share in an intestate succession when the spouse dies, if we're going to give a rebuttable presumption that the decedent parent wants to leave it all to the spouse? Because the child share is extinguished under this bill.
No, if I understand your question, to go back to Senator Branning's example, if it's not there, they would have 50%, and so the children would not get 100% of the property.
Well, if you die intestate and you're an heir.
If you die intestate, which means you don't have a will.
That's right.
Right.
And your parent died, and the surviving spouse is living in the marital home, and there is no provision. She gets a child share, each child gets a share, and she gets exclusive right to the marital home until she remarries. That's how intestate succession,
okay,
as I recall.
yes, I can see that, yes.
All right. So my question is, if you adopt this, then you have made a presumption that you're going to leave it all to the spouse to the exclusion of the children.
Again, it's a presumption, and you know that a presumption can be proven otherwise. It's a presumption if the spouses are living in the homestead, and the presumption is they're married, yes. I mean, we like to promote marriage, certainly as public policy of this state. And so this is simply saying there's a presumption that they were married. And a rebuttable presumption can be overcome.
Well, and I think it even becomes more complex when two adult people get married who have grown children. Under this law, if it was just in one person's name, and that was their primary residence, it's going to exclude
the adult children. I understand.
I don't understand that example.
Well, if two people get married later in life who prior have
Right.
adult children, in testate succession, you inherit as a child, whether you're a young child or you're a full-grown person. And once again, if it was deeded to the wedded couple, who these are not their children, and it's their primary residence, then the presumption is it goes all to the spouse, the surviving spouse.
That's, excuse me, because they're married, that's the presumption based on the way this bill is drafted, yes.
And then the other thing would be, is it primary residence at the time of deed and purchase, or the primary residence at the time of death? Because they could change.
The deed.
Okay.
Now, that's not specifically mentioned in here, but the deed.
So
because you know, when that's created, a tenant in common or right to survivorship is when the deed is conveyed.
So if they buy a second home or they add acreage to it, does it become part of that deed? Because if you buy a second home, and that's why the question is, a married couple who's been married for several years could have had more than one primary residence, and they may not have sold it when they moved to a bigger house.
Well, now, you're saying primary residence. I know for tax purposes, you can only have one primary residence because that's the residence you have homestead on.
But we're attaching this presumption at the time of the deed being created.
Correct.
And I could have a primary residence today, and I get deeded property. My wife and I go buy another piece of property and build a new home. That becomes our primary residence. Is this extinguished? Because at the time I received the deed, that was my primary residence.
I didn't follow your example. I'll just say this, just trying to support marriage in here. I mean, people get married and they get a deed, property conveyed to them, rights of survivorship. That's pro-marriage, so that's all we're trying to do.
Well, I appreciate your support of marriage. I voted against the no-fault divorce, but for this bill, what we're talking about is primary residence, and I'm not trying to be difficult. I'm just saying, clarifying language. Are we talking about the primary residence at the date of death of the spouse? That might help clear it up.
If you want to put an amendment in here, more than happy to accept that.
Okay.
Again, this is a House bill, and it doesn't say to do that.
All right, thank you. Thank you, Mr. Chairman.
And to your point, Senator Sparks, clearly there's some not clarity on this, and I'd be happy to do a reverse repealer at the appropriate time.
Senator Fillingham, for what purpose?
Another question, I'm sorry.
Senator, were you here for a question?
I do.
Senator Fillingham is recognized.
And thank you, Mr. President. Thank you, Mr. Chairman. I appreciate you taking this up. Just based on the answers to the questions Senator Sparks posed to you, so if the instrument is the date of being executed is what you're talking about, you can't file homestead, of course, as you know, until the succeeding year. So if you buy a piece of property in June, you cannot file homestead on that property until the succeeding January.
Correct.
So I don't understand how you're going to rebut the presumption you can't use homestead at the time of the purchase of the property because you can't file homestead on it until the following year. And then the second question along those same lines is, if you have a will stating that I leave, all my real property to Junior, is that a rebuttable presumption? Can you use that? Because as you know, the deed takes effect immediately, whereas the will doesn't kick in until after your death. So if the deed operated under this language to go ahead and transfer it immediately, you never even get to the will. You don't, it doesn't take effect until after your passing. So I guess I'm just confused about what can you use then as the rebuttable presumption?
Well, to that question, I would say, so somebody walks into and I know this has happened, somebody walks into the office and say, here, I have a deed, and my wife passed, and when they deeded it to me, it was supposed to be, I get the property, and you look at the deed and it goes, it doesn't say rights of survivorship. Guess what? It's tenants in common.
Right.
Okay. And I got, you're the second spouse and so then you look at it and you go, and they go, well, that was deeded, back when we were married, and that's not what the deed it says, because it doesn't have the words rights of survivorship in it.
Right.
And so therefore, the assumption at that point, based on the current laws, is tenants in common. And that goes back to Senator Branning's point.
Right.
And so then you have to, in that situation, you have to go and open an estate and get it all squared away, and then they have to come in and testify, when it was deeded, it should have been rights of survivorship, but actually the deed says tenants in common.
Right.
So the same thing applies. You get affidavits and you talk to the right people and you present that. And it being a rebuttable presumption, it only comes up, in my opinion, based on reading this, is when somebody wants to challenge it. And so if it gets challenged in an estate and they say, oh, no, I should have had that, I'm the heir, I should have that. And let's say the spouse comes in and says no, then the spouse, then that heir can come in and say, no, here's A, B, C, and D, here's testimony, this is why I do it, and here's an affidavit, and it was not to be rights or survivorship. And then the judge makes the decision about whether that's rights of survivorship or tenants in common. And if it's tenants in common, then it passes down to the child that's an heir. If it's rights of survivorship, it passes to the spouse.
Right, and I certainly understand the problem. I've seen it in my office many times where people come and say, okay, I want to now sell this piece of property that's mine, and you look at the deed and you're like, well, wait a minute, you can't legally do that because the way the deed was worded, it doesn't pass just to you. It's still 50% yours, and it's 50% all of your deceased husband's heirs. So I understand the problem you're trying to fix. I'm just not sure that this is going to fix it, because the other issue that this would create, and the other time you look at these types of things, is when you're in a title company office and someone's trying to sell property to a buyer, and you're doing this title search, and in the search results it comes back, it was in John and Jane Smith, and now one of them has died and Jane's trying to sell it. Well, can she? I mean, I don't know. It's a rebuttable presumption. So are the title insurance companies involved in this? I mean, are they asking for this clarification?
I haven't been asked for it, no. I mean, they haven't asked me. That's why we have a reverse repealer prepared at the appropriate time to get to this.
Great.
If that'll help.
Sir.
Other questions? Okay, we have an amendment. You're recognized to explain the amendment, Senator.
Yes.
Okay, Senator.
Thank you. This is, my amendment is a reverse repealer. Clearly, there are questions on this. If you adopt the reverse repealer, it'll go to the House. We'll go into conference. I will tell you that I certainly will explain these issues to our House conferees and what the issues are, and try to fix the issues that have been brought up here today. And so my motion, I'd be happy to answer any questions on that. If no questions, then my motion would be that we adopt the amendment.
Questions? Seeing none, all in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. We're on the bill.
Mr. President, if there's no questions, my motion would be that we pass the bill on the morning roll call.
Use of the afternoon roll call?
Yes, I'm sorry, afternoon roll call.
Has been requested. Anyone object to the procedure? Wish to be recorded as voting no. Present. Turner Ford? No. Senator Turner Ford is no. Anyone else? Anyone else? Seeing none, bill passes. Item 72.
Remain on the calendar, and we pass those and remain on the calendar, Mr. President.
Will remain on the calendar, and the remain on the calendar 72 all the way to item 146 will retain their place on the calendar. Are there any announcements? We have an important committee meeting, and we want to get to the committee meeting. Any announcements, please? Senator Fillingane, you're recognized for announcement, sir.
Thank you, Mr. President. Just to remind the Senate that Lydia and I are cooking dinner tonight, and you are all welcome to join.
Thank you, Senator. Senator Thomas.
Thank you, Mr. President. I have a resolution I'd like to introduce out of order.
Please proceed. Senator Frazier.
Announcement, Mr. President.
Please proceed.
I would like to remind the Senate chamber that the Clinton Choir will be singing tomorrow at noon from noon to 12:30. So please come down and support these young people as they sing here at the Capitol.
Thank you, Senator Frazier. It's really special when they do that. Senator Hill,
Announcement.
please proceed.
The Picayune Chamber will be in the Rotunda in the morning and invite you to come by and visit with them. And your Magnolia cookies from Paul's Pastry that everybody looks forward to will be on your desk tomorrow.
Thank you, Senator Norwood, for an announcement.
Thank you, Mr. President. Mr. President, regarding Senator Wiggins' bill, I just wanted to make sure it was understood that my wife may have been listening. I was not inferring that I own some separate property, so I want to make sure that. So I want to put that out. I want to correct that. But I do have an adjourned in memory also. Adjourned in memory for.
It's adjourned in memory for you if you do that. Yeah. So please proceed, Senator.
Adjourned in memory for Henry Sanders Jr., which passed away on Friday night, and Reverend Dee Dee Smith's widow, which is the mother-in-law of Constable Leon Sears, passed away this morning. Thank you very much, Mr. President.
Thank you, Senator. Senator Jackson. Roberts, you're recognized for an announcement, sir.
Thank you, Mr. President. Adjourned in memory.
Please proceed.
When the Senate joined this evening, I'd like to join in memory of former Representative Leonard Henderson from Clarksdale. He died the weekend.
Thank you, Senator. Senator Simmons, D. You're recognized for an announcement, sir.
Two adjourned in memory, Mr. President.
Please proceed.
Thank you, Mr. President. When the Senate adjourns today, I'd like to adjourn in memory of the son of a family friend who died on Friday in a house fire. His name was Gavin White. And also, I'd like to adjourn in memory of Morris Bozeman, which is the father of Willie Bozeman. Thank you.
Thank you, Senator. Senator England, for an announcement, sir.
I'm going to adjourn in memory, Mr. President.
Please proceed.
Senators, when we adjourn today, I ask that we do so in the memory of Miss Catherine Helton, who passed away last week at the age of 96. She's from Van Cleve, Mississippi.
Thank you, Senator. Senator Tate, for an announcement.
Adjourn in memory.
Please proceed.
When the Senate adjourns today, I ask that we do so in memory of Edwin Glenn Gibson, who died over the weekend.
Thank you, Senator. Senator Horn.
Adjourn in memory.
Please proceed.
Thank you, Mr. President. When the Senate adjourns today, I'd like to ask that it do so in memory of longtime educator Mr. Mayo Wilson, who passed away in his sleep yesterday.
Thank you, Senator. Senator Blunt. Announcement passed. Senator Hobson.
Thank you, Mr. President. Announcement. The Senate Appropriations Committee will meet at 5:25 in room 216 to take up a bill.
5:25. Senator DeBar.
Announcement, Mr. President.
Please proceed.
I'd advise the Education Committee, I would recommend that they attend the appropriations meeting as we take up one bill concerning the appropriations.
Thank you, Senator DeBar. Senator Sparks, for an announcement.
Yes, Mr. President, I'd like to hold number 43 from Thursday's calendar, House Bill number 4.
Okay. Senator Barrett. Pass. Anyone else? Anyone else? Seeing none, Senator Pope, you're recognized.
Thank you, Mr. President. I move the Senate stand in recess until the last committee report is filed tonight, at which time the journal will reflect that we are adjourned until 10 a.m. tomorrow.
All in favor signify by saying aye. Opposed, no. The ayes have it.